May it please the court, I want to give just 3 brief historical references before we get to the crux of the matter of the property rights and the possessory interest rights that are at stake here in this case. I'm Attorney Ben Crump, and the fact that I stand before you as a free man and not a slave is a testament to someone's decision to change the course of human history. It is a testament to our legal system, a testament that was led by the courts here in Massachusetts when Chief Justice James Cushing in 1783 judicially abolished slavery in the Crump Walker case. And it is the reason why he is so often quoted, even 250 years later, with the holding that the idea of slavery is inconsistent with our conduct and our Constitution. The second historical reference is from the great Negro abolitionist Frederick Douglass, who once said, "Genealogical trees of Black people do not flourish as a result of slavery." In essence, what Frederick Douglass was saying is what slavery did was destroy the African-American family connection to its ancestry lineage. But this historic case has the ability to not only recognize such lineage, but the right one such lineage of Miss Lanier and her family. And the final historical point, Your Honors, this case presents a case study of Massachusetts' complicated history with slavery. On one hand, it has profited mightily from the cotton trade. Its most powerful institution, Harvard University, has ties with slavery that dates back centuries. In fact, the textile factories, who were the largest donors of the university, helped to build capitalistic empires on the backs of enslaved Africans. In fact, the institution of Harvard and the institution of slavery was born in this country a mere 17 years apart. On the other hand, Massachusetts is also the home of John Adams, and it is not lost on me or Miss Lanier that we're in the John Adams courthouse. John Adams says slavery is the great and foul stain upon the North American Union. Now to get to the crux of the matter, as we've all discussed. Mr. Koskoff so ably explained to the court, property is more than simply an object. Property is a collection of individual rights. It involves the delicate relationships amongst individuals concerning a given resource. And the resource we're discussing here is not merely some image or some photographic negative as suggested by Harvard. Instead, we're discussing the culmination of a malicious and evil scientific experiment in a tortuous conduct of slavery itself in an attempt to legitimize the abhorrent concept that persons of color are property. And this delicate relationship amongst individuals is between Ms. Lanier, Renty and Delia's descendant, and Harvard University. the entity who supported and funded the wrongdoer, Professor Louis Agassiz, even though they want to try to distinguish him now, but it was Harvard who commissioned him, who celebrated him, and who perpetuated him, and who named buildings after him. It's about the right of possessory interest, the right to exert control over a specific property. Giving Harvard the right to exert control over these daguerreotypes is giving them the right to exert control over a piece of evidence, which represents the furtherance of the inhumane and criminal acts against this black man and his daughter 170 years ago.
So if the daguerreotypes had been found, say, by the Boston Globe in a drawer somehow in their building, would you have a different argument? What?
Well, we
Explain
look
that.
at the creation of the daguerreotypes themselves as being something that the court should consider. The truth is, this was a scientific experiment with black human beings being used as lab rats. It was not only a crime against humanity, but it was a crime in the laws of the state of Massachusetts. So it is the creation of the daguerreotypes themselves that are a crime. So Harvard will have you believe that they should have possessory interest above Ms. Lanier and all others because they have this scholarship, this academic proudness that they can disseminate it to the world, and they can educate us on the sins and the history of slavery better than black people, better than Ms. Lanier, and who she chooses to associate with the daguerreotypes of her family. I often think about the woman in gold, which is analogous to this. When she received the artwork back after it had been taken from the Nazis during the Holocaust, I don't recall the argument coming, what would she do with the daguerreotypes? And I think it's it's not proper to say, what would Ms. Lanier do, as if this black woman could not work collaboratively with a museum to be able to protect the First Amendment interests, to further educate
I'm sorry if you
people.
misunderstood. My question was not what will she do with them if she wins? My question is, how would your case differ, if any, if the daguerreotypes had been found in a drawer of the Boston Globe?
Yes, ma'am, Your Honor. We would ask this court, as we're doing today, to give her the opportunity to go forward before a jury to be able to prove her case while her possessory interests are greater and superior to anybody else's. This is a small ask when you think of the scope of the great wrong that has been done. All Tamara Lanier has asked to do from day one is to be able to prove that that man and that woman are her great-great-great-grandparents. And as Mr. Koskoff says, she did it miraculously, painstakingly, something that black people were never supposed to be able to do because of slavery. I hope that addressed your question, Your Honor.
Yeah, so your position is that her rights are superior to anybody else's rights. In this case, though, Harvard is actually the wrongdoer, so should have no rights.
Yes, ma'am, Your Honor.
How do we deal with the fact that she's one of, I take it, many descendants?
Again, Your Honor, that is a matter that should not be manifested by Harvard. That should be something that once it is proven in a court of law before a jury, then we can address that matter. Ms. Lanier is fully aware that she understands she is but one descendant of Papa Rente and Delia. But to let Harvard, retain the daguerreotypes is like catching a thief red-handed and the court allowing the thief to legally keep possession of the property. It would offend all concepts of equity and justice to leave the daguerreotypes in Harvard's unclean hands. I beseech this court to ask Harvard what is the basis of its possessory interest claim, the basis of Harvard's right to continue to exert control over these daguerreotypes. Harvard has been silent on this question, just like the thief pointing fingers at everybody else
But if we're
except
looking,
themselves.
I'm sorry to interrupt.
Yes.
But if we're trying to define what the property right is here, let me make sure that I understand your definition of the property right that your clients have. If somebody is a victim of a despicable crime, and if the person who took the photograph of that despicable crime occurring, or was complicit in the taking of that photograph or daguerreotype, as we have here, then the victim of the crime retains ownership of the photo or
So,
daguerreotype.
Your Honor,
I'm sorry.
I
just
think
let
I
me-
understand your question, and I would put forth, Your Honor, this is a case not just about property rights. It is also about possessory interests. And when you think about that, you go back and you look at the case law that says property is a collection of individual rights determined by state law. Part of the crucial rights are the right to exclude or the right to use. It's not something that simply refers to the object itself. And so when you look at this bundle of sticks that has been often quoted, Justice Sotomayor recently quoted it in Manhattan Community Access Corp. Versus Halleck, and she quoted U.S. v. Kraft, Supreme Court decision in 2002. I only make reference to those to understand the complicated nature of possessory interest and why we feel we should be allowed to go forward before a jury to argue that the possessory rights as Ms. Lanier's descendants, who were the victims of a heinous crime, should be able to go forward. And I hope that our father explained that what we're asking for here today is not novel. There is a precedent in the law, and we have the legal vehicles to accomplish the ends to righting this past wrong and creating a more just future. In this moment, the law, through concepts of replevin, conversion, equitable restitution, and prima facie tort, provides this court, and this court profoundly, with opportunities to correct this grave injustice. Courts throughout this nation and the world have used similar concepts to free society from the heavy burden of an injustice, of a sin that has not yet been atoned. As the court aptly stated in 1871 in the case of Walker v. Cronin, one of the aims of the common law has always been to protect every person against the wrongful acts of every other person. Harvard has kept Renty and Delia enslaved for 170 years. This court has the ability to finally free Renty and Delia from bondage. Renty and Delia were condemned in life as property of their slave master. We are beseeching this court not to condemn them in death to be the property of Harvard for all eternity. I conclude simply with this. The legal system found ways to return the belongings of Japanese Americans interned in prison camps, of returning possessions taken from the Jews by the Nazis, and now it is time to return these daguerreotypes to Miss Lanier and her family who descended from these enslaved Africans. This is not a case governed by a limited legal precept that a subject of a photograph has no property interest in such a photograph. Moreover, this court, and this court most profoundly, has the power to provide Ms. Lanier simply with the opportunity to be able to prove that she has a superior possessory interest over Harvard. And I would suggest, Your Honors, her request to go forward and have an opportunity to prove her case before a jury is quite small in the scope of such a great wrong. Thank you, Your Honor.
Thank you.